bite-sized podcasts published by the Meritas EMEA Employment Group. Periodically, members of our practice group get together to discuss interesting and topical cross-border issues. Meritas is the global alliance of leading independent law firms dedicated to helping clients access top-tier legal expertise from anywhere in the world. I'm Sam Murray-Hinds, and I'm a lawyer at the law firm Howard Kennedy in London. I also head up the Meritas EMEA Employment Group. Welcome to today's episode. Today, I'm joined by Annette Baum from Lexens in the Netherlands and Christine Slotnes from Brekkhus in Norway. Both are employment lawyers and specialists. And our discussion today is on employers of record. And use of this structure is becoming increasingly popular, and we're advising on it more and more. So the first question really is, what is an employer of record? So this is where a company doesn't have a legal entity in a particular territory. And while it could hire an employee in that territory directly, it has the headache of setting up payroll, which would normally be done through a local provider. It would also manage the kind of pensions and benefits side. And in addition to that, the company would need to manage the day-to-day relationship with the employee, so dealing with HR matters and local laws that it might not be familiar with. And this is where the employers of record come into play, as they act as the employer and deal with all the admin to include payroll and compliance with local laws and employment legislation. And they contract directly with the individual and provide that individual's services back to the company. The company gets their chosen candidate carrying out the role, and the employer of record facilitates that onboarding, as well as the termination and offboarding process at the end of the relationship. And that brings me on to today's discussions, because in some jurisdictions, employers of records are not either allowed to operate, or where they do operate, companies need to be aware of the pros and cons and ensure that they protect their business accordingly. And today my guests are going to highlight for us some of the differences between the Netherlands and Norway and the structural issues around the employer of record relationship. So I'm going to be asking them the same questions so we can compare. I'm going to start with Annette. Welcome to the podcast. Can you tell us a bit about the position in the Netherlands? So if you have a foreign company that is looking to hire someone who lives in the Netherlands, does it need to have a legal entity there?
No, that's not necessary. So if as a foreign company, you can perfectly employ Dutch employees who work and live in the Netherlands. So it's not an obligation from a Dutch law perspective to have a legal entity in the Netherlands itself to be able to employ employees.
Okay, and Christine, welcome. Same question to you as well in respect of Norway.
Thank you, Sam. Well, it's different in Norway because here you need to have a legal branch, a legal entity. So at least a branch of the foreign company actually to be able to employ in Norway. But that's basically for actually being able to pay the employees actually. So it's for tax reasons, I would say.
Okay, and switching back to Annette again, I mentioned in my intro that some jurisdictions prohibit the use of employers of record and others just have regulations in place around them. So can you use an employer of record in the Netherlands?
Yeah, that's absolutely no problem at all. You can use it, and for a long time it was used quite frequently. And then the employer of record tried to use our rules and regulations we have for temporary agency workers. And the upside from that was that you have much more flexibility and you can use, well, more cheaper employees than regular employees. But then a few years ago, the legislator thought that it was not desirable to have it that way. And so the employer of record has a specific employment agreement within Dutch law and with specific rules for it. So it is definitely allowed, and it is also, well, quite often used by foreign companies, but it doesn't have anymore the flexibility and the financial upside that it used to have.
Thanks. So jumping around cross-border here, going back to Norway. So Christine, what's the position in Norway? Can you use employers of record there?
Well, there is no, it's not pronounced in the law or anywhere else that you cannot use them. But the labor law framework in Norway makes it difficult because the protection of employees in Norway, that is really strong. And the general rules is that employees, they should have a direct and permanent employment relationship with their employer. And then the employer has management rights over the employee and also responsibilities for social securities, but also for, health, safety and environment responsibility. And that makes a setup with an employer of record difficult in Norway because there will be a question of who's really having the management rights here, who is having the obligations as an employer here. And I've seen quite a few of employment of record agreements between the employer of record and the company actually using their services. And there are quite a few of those agreements who is, putting all the responsibilities on the companies actually hiring the employees here. So they may be under Norwegian law and most likely considered to be the actual employer when it comes to the end of the day.
Yeah, because it seems like the position in the UK, it's probably a bit easier to use them here. And I know they're very popular, or they're starting to become more popular, particularly with US entities that want to kind of hire someone within the UK where they don't have a sort of legal entity here to be the employer. But there's a tension between the management of someone on a day-to-day basis. So although the employer of record is the legal employer through all the paperwork, actually in practice, the person who's managing that individual on a daily basis is the company.
Yeah.
And so I can imagine, and I haven't seen many cases yet, and I assume that's because they settle, but I can imagine individuals trying to challenge who their actual legal employer is and then trying to bring claims against them as well. So it's interesting to see how this might play out the more that they're being used. So that kind of moves us on nicely actually to the employment conditions. And yet we've covered that the employer of record is the legal employer, but what about the employee rights? So are they subject to the terms and conditions that the employer of record chooses, or do they have any entitlement to the same benefits that maybe the direct employees of the company that's hiring them? Are they allowed to have parity?
Well, it's actually the latter. So if the hirer has employees hired itself directly, then the employees from the employer of record need to be compensated exactly the same as the employment conditions that the direct employees of the hirer has. So that's important to realize, that you really cannot differ from employment conditions or financial compensation that the employees of the hirer has. But if the employer of record hires them on their own terms, and the company that hires the employees doesn't really have any employees of its own, so direct employees, then of course the conditions of the employer of record can be used. But it's important to realize, I think, that based on European civil law, if you're working and living in the Netherlands, you are always entitled to the basic employment conditions that are applicable in the Netherlands, such as vacation days, holiday allowance, minimum wage, maternity leave, payment during sickness. And so that's especially for foreign companies. We have very strict employment laws as well, the same as Norway, which means that especially in cases of dismissal and sickness, well, foreign company must realize that it will be most likely charged by the employer of record if these costs are going to be increased. So, for example, in the Netherlands, if you call in sick, you are entitled to payment of your salary during a period of maximum 2 years. So that will be, of course, charged by the employer of record to the company that's hiring the employees. So that's important to know.
Yeah, I think in the UK, the way that it operates here is that the employer of record has their template employment contract, and that's how they hire the individual. And then they'll pass on the cost, obviously, to the hiring company, higher, obviously, than what they're paying directly to the employee. And then there's obviously another charge to kind of access their platform and the HR support that they need on a day-to-day basis. But there isn't that same sort of argument about parity with direct employees of the hirer, because we're not talking about a kind of agency type relationship where agency worker regs might kick in. And I know in some jurisdictions, I think Germany, the position is very different. which would be really interesting to hear from you now, Christine, because it sounds like the position is a bit more complicated in Norway with using this model. And I wanted to hear your take on the kind of employment conditions that would apply.
Yes, it's kind of similar to what Anette just mentioned, because as long as you are an employee in Norway, you have some legal entitlement to benefits, through the law. And as an employer, the legal employer, which would actually be the employer record, as on paper, they will have the obligation to actually make sure that the employee has all the benefits and rights that it has according to law. But at the end of the day, if the employer record is not providing the employees with the correct benefits and rights, there is a question if the employee can actually go to the hirer in this, the hiring employer here, and claim the same benefits and rights that they are entitled to according to law. But whether or not they are entitled to the same benefits and rights that the permanent employees has in the company who's hiring the employer record, that's another question, because they will not be considered agency workers, because if an employer is hiring employees from an employment agency, that's a different thing in Norway. But as an employee in Norway, you have some legal rights and some benefits, and the employer record would have to make sure that the employees has all these rights and benefits.
Okay, thank you. And my final question to both of you is whether you could both just summarize the main points around what the upside of using an employer of record is. So Christine, if I come back to you for that one, what's the upside?
Well, I actually discussed it with a tax partner before I came into this discussion, and we did agree that we would say that in Norway there is actually no upsides with it, because there is so much risk involved, and there is also a big risk with concern to concerning the costs of this actually. So to be honest, that's not a setup that we would advise our clients to do here in Norway. But there's always, different cases, and in true lawyer spirit, we would have to look into the facts of each particular case. But, we would say that as a main opinion here, we would say, well, we don't advise people to do this.
And yet, same question.
Well, I could advise a client to do it, especially if you only have a few employees in the Netherlands, because it saves you from a lot of administrative issues. You don't have to establish a legal entity. Oh, that's not obligated, of course, but you have to have some payroll company to pay salaries and reimbursements in any event. So if you outsource it to an employer of record, then you don't have any administrative burdens regarding Dutch law, sickness, reintegration issues, dismissal, but also onboarding and offboarding will be done by the employer of record, and you don't have to familiarize yourself with Dutch law at all, or employment law, because you have someone who is taking care of it. But financially, there isn't really an upside, because you do have to pay the same employment conditions. And of course, as Sam was already explaining, you also have to pay, of course, some sort of margin to the employer of record for this burden and for this service. But from an administrative perspective, it can be very useful and, easy.
Can I just have one comment there? Because what I've seen in quite a few of the contracts for employer records is that the employer record is anyway putting the risk back on the companies actually hiring the services.
Yeah.
So
financially, yes.
Yeah. So from my perspective, I would say that even though it would work, you still have the risk.
Yeah, I'd agree.
Yeah, well,
I've
the risk,
seen
financially
the
you definitely have. But you don't have to have all the paperwork for hiring and during sickness and company doctors and onboarding and offboarding, tax law, payments, that will all be taken care of. So if you are in a foreign country outside the Netherlands and you only have 2 or 3 employees in the Netherlands, it will be a lot of work to get acquainted with that and to set it all up. But then you financially, of course, it will all be passed on to the foreign company, definitely.
Yeah.
Yeah, I mean, I think I've obviously seen, like you, Christine, saying about seeing these terms that are in place between the employer of record and the hiring company. And no employer of record is the same. They're all different. So it's about finding the right one. But you're right, like things are great when the relationship's going really well with the individual. But as soon as things start going wrong, like there's performance management issues, particularly where they've got 2 years service in the UK, so they've got unfair dismissal rights, or you've got a grievance or discrimination complaint, and the employer of record is having to handle that even though they're kind of one step removed because they're not there on the floor on a day-to-day basis. I think that's where things get a bit tricky, and the kind of relationships it's important to manage who's doing what and get the right support from the employer of record and keep the communication between all those parties. And then there's also the risk that I mentioned before about the individual challenging who their actual legal employer is in reality. And then we've already touched on the indemnities as well. So as the hiring company, you have to be really careful about what your employer of record is doing, because at the end of the day, you're liable for their actions, and you want to make sure that they're
and at the same time,
it.
you have to be sure that you have that as a hiring company, that you also keep in mind what's important, right? Because I do have experience with cases that the hiring company just dismissed someone and suspended an employee and sent them home. While in the Netherlands, you're not allowed to unilaterally terminate an employment agreement. You always need some sort of preventative test. And so the employee was sent home, and the hiring company did not inform the employer of record about his actions. And so there was some time in between, and that was all from a legal perspective. It was like it did a lot of damage to the eventual dismissal case, because it was not handled well in this situation by the hiring company and not by the employer of record. So you have to make really solid, extensive agreements between the parties in order to make it work.
Yep,
Yeah.
That's a really, really good point.
Yeah, and that's why we can sum it up that we have to look into each individual case actually here, because as you also said, Sam, you have to find the best employer of record. And there are so many different employer records out there.
Yeah. So to bring things together at the end, we always like to finish on a practical note, and just taking from our discussions today. Essentially, employers should be considering whether an employer of record can be used in the territory that they're looking to operate in. An employer of record might be fine in one country, but it might not be considered compliant with employment laws in the neighbouring country. Also, in some countries, employers of record are classed as employment agencies and are subject to differing legal classifications, considerations, and regulations. Employers of record will often use their own temporary employment contracts, and we've discussed the point around the terms of those. But because the contract is between the employer of record and the individual, the company needs to think about what it needs to protect. And by that, I'm talking about its IP and its confidential information. So in the UK, we would address that by using a side agreement, and that would be between the company and the individual. And that would mean that the individual's entering into an agreement with the company directly in relation to certain protections. That brings me on to talking about post-termination restrictions, which is a really important factor as well. So does the company have the benefit of any restrictions that the employer of record has in place with the individual? And that means also looking at whether the contract between the employer of record and the company that's hiring dealing with the kind of support and action that they might want the employer of record to take in the future if they want to enforce any of the provisions around protecting confidential information or the restrictions. And also sometimes I see them contained in these separate agreements, but you also need to consider, firstly, are they drafted properly? And secondly, has there been consideration, whether monetary or otherwise, to make sure that they're actually binding in practice? And data protection is another aspect that I find is often overlooked. So there will be personal data flowing between the employer of record, the individual, and the company. And if you're talking about people's medical records, if they are sickness absences records, that could include special category data too, which requires a different protection. And if you've got data transferring outside of the EU, for example, to the US, you need to consider whether you need an international data transfer agreement. And I found that often this is not adequately covered off in the agreement between the company and the employer of record. And I think a really good summary of today's discussion is that it's really important for the company to do its homework and to take legal advice to help best protect its business and to find the right model for it. And as Christine has said a number of times, quite rightly, it's about looking at things on a case-by-case basis. I think that brings us nicely to the end of our episode today, but if any of our listeners have any questions or comments on this subject, do please get in touch with your Meritas contact firm. We'd be very happy to continue the discussions. Or if you'd like to find out more about Meritas, you can do so via the website meritas.org. And that just leaves me to thank Annette and Christine for joining me today, and we hope you'll tune in next time. Thank you.